Today we'll have a look at the sedition law which was in news recently. In the year 2021, the Chief Justice of India had questioned as to why a colonial law used against Mahatma Gandhi and Bal Gangadhar Tilak continued to survive in the law book after 75 years of independence. The Chief Justice had said that sedition or Section 124 Alpha of the Indian Penal Code was prone to misuse by the government. What has been the Supreme Court's verdict on the sedition law? The Supreme Court, in determining the legality of Section 124 of the IPC, has raised the bar for the government to invoke the provision, saying that it will be desirable not to proceed with the charge of sedition until the government evaluates the provision. The statute of sedition is effectively suspended until the court hears the matter again in July. The petitioner's case is that the section of legislation comes from 1898 and it predates the constitution and is therefore being misapplied. On a previous date of hearing, the Attorney General had also cited several examples of blatant misuse of this law. As a result, the Supreme Court of India mentioned that they will anticipate that governments will refrain from using the provision of legislation until the re-examination of the provision is completed. Although the court did not expressly stop the provision, no current criminal statute has ever been stayed by the court. It effectively halts its execution. The court ruled that cases that are currently before trial will be held in abeyance and that it will hope and expect that governments will refrain from filing new FIRs, investigating cases, or adopting coercive action against accused. If a new case is filed under Section 124 Alpha of the IPC, the affected parties are free to approach the appropriate courts for relief and are free to seek appropriate remedies from the respective courts. The courts are to evaluate the relief sought, taking into mind the current ruling as well as the Union of India's unambiguous position. The Supreme Court has placed the onus on the government to guarantee that no frivolous sedition charges are filed to abuse the law despite the judiciary's prohibition. The federal government informed the court that it would issue a direction to states and union territories on how the sedition statute would be used in the future. The government has sought more time to submit its written response to the petitions challenging the constitutional validity of Section 124 Alpha of the IPC dealing with the offence of sedition. Sedition laws were enacted in the 17th century England when MPs believed that only positive government beliefs should be allowed to exist, as negative opinions were harmful to the government and monarchy. The sedition law has its origins from the Wahhabi movement. The law was drafted in 1837 by British historian and politician Thomas Macaulay when it considered the necessity for a separate section to deal with the offence of sedition. An amendment was offered by Sir James Stephen in 1870 and inserted as Section 124 Alpha of the Indian Penal Code. In 1891, the sedition law was also imposed against Jogendra Chandra Bose, editor of Bangobasi, for criticism. It has been famously used against Mahatma Gandhi, Bal Gangadhar Tilak, and Annie Besant. In 1897, the IPC Amendment Act replaced the present Section 124 Alpha as the Act of Sedition. Coming on to a brief about Section 124 Alpha. Section 124 Alpha of the IPC refers to sedition, that is, conduct or speech which results in mutiny against the authority of the state. It places a reasonable restriction on right to freedom of speech. It defines sedition as an offence committed when any person, by words, either spoken or written, or by signs, or by visible representation or otherwise, brings or attempts to bring into hatred or contempt, or excites or attempts to excite disaffection towards the government established by law in India. Disaffection includes disloyalty and all feelings of enmity. However, comments without exciting or attempting to excite hatred, contempt, or disaffection will not constitute an offense under this section. What are the punishments which are applicable on imposition of the sedition law? The sedition law is a non-bailable offense. The punishment under section 124A ranges from imprisonment up to 3 years to a life term, to which a fine may be added. It is a cognizable offense and triable by court of session. A person charged under this law is barred from a government job for life. They have to live without their passport and must produce themselves in the court at all times as and when required. Coming on to the restrictions imposed by sedition and freedom of speech. As per Article 19(1) alpha of the Indian Constitution, all citizens have the right to freedom of speech and expression. Article 19(2) states that every citizen has a right to air his or her opinion through the printing or electronic media with restrictions imposed. Freedom of speech and expression are supposed to be the first and foremost human right. It is the first condition of liberty and makes life meaningful, facilitating a balance between stability and social change, and having reasonable restrictions to be imposed on this right is a basic fundamental requirement. Balancing freedom of speech and expression with collective national interest is one of the key ingredients of the sedition law. The Law Commission has suggested that every irresponsible exercise of right to free speech and expression cannot be termed seditious. Expression of thought which is not in consonance with government policy is not to be presumed as seditious. Let us have a look at the issues. The sedition law has been criticized to be having its origin from the colonial era. The government has been criticized for use of the sedition law, stating that people must be at liberty to show their affection towards the country. Section 124 alpha should be invoked only in extreme cases where the intention behind any act is to disrupt public order or to overthrow the government with violent and illegal means. Some things, like berating the country or a particular aspect of it, cannot and should not be treated as sedition. Every restriction on freedom of speech and expression must be carefully scrutinized. Power. The higher judiciary should use its supervisory powers to sensitize the magistracy and police to the constitutional provisions protecting free speech. The definition of sedition should be narrowed down to include only the issues pertaining to the territorial integrity of India as well as the sovereignty of the country. Society must take the lead to raise awareness about the arbitrary use of sedition law. To conclude, the Law Commission has conveyed that every citizen has the right to voice his opinion, even if it meant dissent with the policy of the government of the day. The Commission has invited views of all stakeholders so that a public-friendly amendment could be brought out. With this, we have come to the end of our discussion on the recently concluded debate on sedition law.